just to set it off, do you feel that these court orders, some have been arguing that they've been overtaken by events, do you feel they still are in place?
So first of all, let me clarify that what we have is conservatory order.
Okay.
Conservatory order is the most powerful kind of constitutional order. It is like a four-dimension court order. It is more powerful than an injunction. It is more powerful than an order of stay. A conservatory order is a 360-degree order. It applies in time, stopping what has happened in the past, preventing something to go on in the future, and even impacting the present. So when you look at the exact wording of the court orders that have been issued, both in Nairobi and in Kerugoya, they are conservatory orders stopping implementation of the impeachment resolution of the Senate. What this means is that it doesn't matter how much implementation had already taken place by the time the order was issued. Any further implementation is stopped by the court order. So that means that we are in a situation as if those additional actions, beginning with the removal from office, which was a direct consequence of the impeachment order of Deputy President Rigathi Gachagua, the proceedings in the National Assembly today, the voting to select Professor Kithure Kindiki, all those have been stopped by a conservatory court order.
All right, so if the state was to proceed with swearing in Kithure Kindiki tomorrow, as it is, they would be going against the law, just for clarity?
In fact, they will not only be going against the law, they would be committing an act of contempt of court. It would be, I think, quite a serious action. Those who do it might end up finding themselves engaged in an impeachable offense, and they might face sanctions from the court, including sanctions relating to their continuation in whatever public office they have. The court orders are very serious issues. They have to be complied with. And I think I also need to clarify that any action undertaken in violation of a court order is considered a nullity, null and void, and of no legal effect. It would be the same as two children playing a game of make-believe. It would have no effect regardless of who does it. Until the court order is lifted or set aside, it has to be complied with.
So what options does the government have? Is it something that the office of the Attorney General could now step in, and what can be done if they want to, so to speak, salvage the situation from where they stand?
The way to salvage the situation is as follows. The politicians and the political process played its way out, including the quasi-judicial process in the Senate. The courts have now asserted that they have a right to review the proceedings that took place in the National Assembly and the Senate. So it is now the time, based on our constitutional architecture, for the courts to have an opportunity to review what happened. So the Attorney General would have to get lawyers, either his own staff or external lawyers, or a combination of both, to participate in the court proceedings. They can always make an application seeking to review or set aside the decisions that have been made. But that application would be heard by the 3-judge bench that is expected to deal with the matters on Thursday next week. So there are not much options between now and Thursday, because even if they were to do an application for setting aside, it would probably also come up for hearing on Thursday next week.
All right. And I've seen also conversations